Indiana Constitution as amended in 2018. The current Indiana Constitution was adopted in 1851, replacing Indiana's first Constitution of 1816. The current Constitution has been amended 24 times since 1970. The most recent amendment to the Indiana Constitution was approved by voters in 2018. There are a total of 16 articles in Indiana's Constitution. Of the 16 articles from the Indiana Constitution, this video will feature Article 1, Bill of Rights. Indiana Constitution as amended 2018, Article 1, Bill of Rights. Section 1. We declare that all people are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that all power is inherent in the people, and that all free governments are, and of right ought to be, founded on their authority and instituted for their peace, safety, and well-being. For the advancement of these ends, the people have at all times an indefeasible right to alter and reform their government. Section 2. All people shall be secured in the natural right to worship Almighty God, according to the dictates of their own conscience. Section 3. No law shall, in any case whatever, control the free exercise and enjoyment of religious opinions or interfere with the rights of conscience. Section 4. No preference shall be given by law to any creed, religious society, or mode of worship, and no person shall be compelled to attend, erect, or support any place of worship or to maintain any ministry against his consent. Section 5. No religious test shall be required as a qualification for any office of trust or profit. Section 6. No money shall be drawn from the treasury for the benefit of any religious or theological institution. Section 7. No person shall be rendered incompetent as a witness in consequence of his opinions on matters of religion. Section 8. The mode of administrating an oath or affirmation shall be such as may be most consistent with and binding upon the conscience of the person to whom such oath or affirmation may be administered. Section 9. No law shall be passed restraining the free interchange of thought and opinion, or restricting the right to speak, write, or print freely on any subject whatever, but for the abuse of that right every person shall be responsible. Section 10. In all prosecutions for libel, the truth of the matters alleged to be libelous may be given in justification. Section 11. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search or seizure shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or thing to be seized. Section 12. All courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. Section 13a. In all criminal prosecutions, the accused shall have the right to a public trial by an impartial jury in the county in which the offense shall have been committed, to be heard by himself and counsel, to demand the nature and cause of the accusation against him, and to have a copy thereof, to meet the witnesses face to face, and to have compulsory process for obtaining witnesses in his favor. Section 13b. Victims of crime, as defined by law, shall have the right to be treated with fairness, dignity, and respect throughout the criminal justice process, and as defined by law, to be informed of and present during public hearings and to confer with the prosecution, to the extent that exercising these rights does not infringe upon the constitutional rights of the accused. Section 14. No person shall be put in jeopardy twice for the same offense. No person in any criminal prosecution shall be compelled to testify against himself. Section 15. No person arrested or confined in jail shall be treated with unnecessary rigor. Section 16. Excessive bail shall not be required. Excessive fines shall not be imposed. Cruel and unusual punishment shall not be inflicted. All penalties shall be proportioned to the nature of the offense. Section 17. Offenses other than murder or treason shall be bailable by sufficient sureties. Murder or treason shall not be bailable when the proof is evident or the presumption strong. Section 18. The penal code shall be founded on the principles of reformation and not of vindictive justice. Section 19. In all criminal cases whatever, the jury shall have the right to determine the law and the facts. Section 20. In all civil cases, the right of trial by jury shall remain inviolate. Section 21. No person's particular services shall be demanded without just compensation. No person's property shall be taken by law without just compensation, nor, except in case of the state, without such compensation first assessed and tendered. Section 22. The privilege of the debtor to enjoy the necessary comforts of life shall be recognized by wholesome laws, exempting a reasonable amount of property from seizure or sale for the payment of any debt or liability hereafter contracted, and there shall be no imprisonment for debt except in case of fraud. Section 23. The General Assembly shall not grant to any citizen or class of citizens privileges or immunities which, upon the same terms, shall not equally belong to all citizens. Section 24. No ex post facto law or law impairing the obligation of contract shall ever be passed. Section 25. No law shall be passed, the taking effect of which shall be made to depend upon any authority, except as provided in this Constitution. Section 26. The operation of the laws shall never be suspended, except by the authority of the General Assembly. Section 27. The privilege of the writ of habeas corpus shall not be suspended, except in case of rebellion or invasion, and then only if the public safety demand it. Section 28. Treason against the state shall consist only in levying war against it, and in giving aid and comfort to its enemies. Section 29. No person shall be convicted of treason, except on the testimony of 2 witnesses to the same overt act, or upon his confession in open court. Section 30. No conviction shall work corruption of blood or forfeiture of estate. Section 31. No law shall restrain any of the inhabitants of the state from assembling together in a peaceable manner, to consult for their common good, nor from instructing their representatives, nor from applying to the General Assembly for redress of grievances. Section 32. The people shall have a right to bear arms for the defense of themselves and the state. Section 33. The military shall be kept in strict subordination to the civil power. Section 34. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Section 35. The General Assembly shall not grant any title of nobility, nor confer hereditary distinctions. Section 36. Immigration from the state shall not be prohibited. Section 37. There shall be neither slavery nor involuntary servitude within the state, otherwise than for the punishment of crimes, whereof the party shall have been duly convicted. Section 39A. The right to hunt, fish, and harvest wildlife is a valued part of Indiana's heritage and shall be forever preserved for the public good. Section 39B. The people have a right, which includes the right to use traditional methods to hunt, fish, and harvest wildlife, subject only to the laws prescribed by the General Assembly and rules prescribed by the virtue of the authority of the General Assembly to promote wildlife conservation and management and preserve the future of hunting and fishing. Section 39C and D. Hunting and fishing shall be a preferred means of managing and controlling wildlife. This section shall not be construed to limit the application of any provision of law relating to trespass or property rights.